and hereby provide an incentive for the EPO to make regular use of search work already carried out by national patent offices. And it is in this way that it should interconnect with utilization projects, as we have heard about before, and thus facilitating the utilization of all available resources and reducing duplication of work. So if we turn to the European and Community Patents Court then, the main thing that has happened during this year is that the Council in June requested the opinion of the European Court of Justice on the compatibility with the EC Treaty of the draft agreement. The Member States have been given the opportunity to file written observations to the Court of Justice, and an hearing will be held, hopefully during this year. We don't know that. Since the opinion of the ECJ cannot be expected during the Swedish presidency, we are now focusing our efforts on some of the major outstanding technical issues, such as the composition of the panels of the first instance, the handling of actions for revocation in an already pending infringement case, and the language of proceedings of the first instance of the proposed court. So, where we will be in December, that is very difficult to say. It's difficult to predict. What is clear, though, is that we now have a clear political momentum and a strong commitment from the Member States to achieve real progress. So thank you very much for your attention, ladies and gentlemen.
Thank you very much for your very concise introduction, and I think it's clear from your introduction that we all should be somehow ashamed when you don't manage to find an agreement before the December Council. I would like to invite the next speaker, Thomas Tindemans.
I will offer you one general observation and one very concrete idea on IPR. When I started working in the law firm I'm with, and I should declare that I'm speaking today on behalf of a coalition of industrial manufacturing companies who have problems with the lack of IP protection. But when I started working in the law firm about 20 years ago, the intellectual property specialists were sitting all together in one corner and were considered propeller heads with whom decent business lawyers had nothing to do. When I look at what's happening today, intellectual property is an integral part of practically all fields of law we practice. Competition law, trade law, internal market regulation. You see that there has been a huge development from rather abstract legal concepts to very concrete business elements based on IPR. And that, in my view, reflects somewhat the society's or demand for innovation, the virtuous circle by which investment, creation, innovation put to the market and then reaping the reward from it. That careful balance and that virtuous circle is in place in order to respond to society's demand for new products and services. Once we start fiddling with it, once we interfere with it, we see that we fail to produce the demands that the world expects from us. So intellectual property rights are not about abstract theoretical rights. They're very concrete, and here I come to my concrete proposals. Two brief examples. A European tyres manufacturer explores new ways of producing tyres, innovates tyres, and uses them, tries them out in Formula One races. They had their tyres stolen, and less than 6 months later, exactly the same tyres appeared on the European market, imported from, in this case, Asian countries. These prototypes were not protected by patents or copyright, one, because the innovation was probably not yet ripe for it, but secondly, the time it takes to obtain those protections, especially patents, is so long that probably the lifespan of the innovation is far exceeded. Nevertheless, the company suffers because competitors undercut prices and appear on the market with the stolen know-how, the stolen trade secrets. Second example, a European company develops a very energy and efficient air conditioning system by assembling existing technology in a special way. They license it for the Chinese market with a Chinese partner, and a few months later that Chinese partner starts submitting similar products and systems on the European market without any authorization, without any intellectual property respect, and gets funding for eco-friendly air systems out of the European budget. This demonstrates the importance of trade secrets and of know-how, because that is how innovation takes place in reality. It is no longer the professor who retires for 10 years in his laboratory and then comes up with the wonder invention and then goes for a patent. It is a daily activity in companies, organizations, and there is often not even time to consider legal consequences of proper protection. So we need the trade secret and know-how protection that is available under the World Intellectual Property Organization rules, and that is recognized by the European Court of Justice, notably in the landmark Microsoft case. However, in the European Union, there is no harmonized recognition of trade secret and know-how protection, and that is something the companies I represent would urge the European institutions to consider. With a small amendment to the IP Enforcement Directive and to the Customs Code, we could prevent or at least reduce the number of products based on stolen technology that enter the European market and undercut the true innovators.
I think we can now move to Edith Hedgehog, Member of the European Parliament.
Thanks, Josh, very much. Last time we met on innovation, I think in the Budapest conference, when we discussed that social innovation is as important as the material innovation we normally speak about. However, ladies and gentlemen, as a member of the European Parliament who worked in the last 5 years on the Lisbon strategy and on the small businesses, let me start from other end of the issue and finally arrive to the intellectual property rights. In the last 10 years in Europe we built a knowledge-based economy called Lisbon Strategy, and in the last 10 years while we build this Lisbon highway we have to face the phenomenon that quite a small number of cars are moving on that highway, and certainly the small and medium-sized businesses are not among those drivers on that Lisbon highway. So in the last 5 years we worked hard together with the Commission to analyse the situation, and we learned the hard numbers that only 8% of the companies are dealing at this internal market, and only 15% of their turnover for these 23 million small and medium-sized companies are generated in more than one member state. So everyone can be very happy and grateful about the success and the status quo he preserves, but certainly the numbers are proving that European internal market is not 100% efficiently used. And I think this is where we have to start from, especially when we are talking about how to improve business success with our legislative tools over Europe. And this is what we have done with the Small Business Act, because we said that one way is to increase business success is to increase the turnover of the companies to get out to the European markets and to the world market, supported by the legislative system. The second we learned